To the afternoon session of the Colorado Oil and Gas Conservation Commission. We are focused on Rule 1200, the wildlife series of our penultimate rulemaking in the mission change rules. We heard from staff this morning, and I believe we are going to roll right into party presentations with a 40-minute cap presentation by the industry group. And Ms. Larson, if you're with us, do I have that right?
Yes, you do. And forgive me, let me get my video going. You do have that correct. So we will start bringing in that panel and get that teed up.
Good afternoon, Mr. Mathews. I see you've unmuted. Are you going to lead this for us this afternoon?
Yes, I am, Chair Robbins. Before I start, I do want to make sure that Ms. Wazelinski is participating. Her computer crashed about 2 minutes ago, and she's doing this by phone. So she will be calling in.
Okay, let us find her before you get going, and we'll
Thank
make
you.
her a
Appreciate
panelist.
it.
I'm here. I am on my phone.
The wonders of technology. Well, good afternoon. The industry bloc would like to thank the Commission for the opportunity to present these remarks with respect to the latest draft of the 1200 Rule Series. We will have 5 witnesses this afternoon. Lindsay Ryder of Karis Oil and Gas will testify that the high priority habitats listed in Draft Rule 1202C should include a waiver process with CPW. She will also testify that the high priority habitat for aquatic species should remain at 300 feet, and the proposed high priority habitat for greater sage grouse should remain at 0.6 miles. Ms. Wazelinski of Jost Energy Law will then discuss the proposed 500-foot setback from staging, fueling, and chemical storage areas in 1202A3. She will discuss why a general riparian setback is neither reasonable nor necessary and should be rejected. Jim Martin will then testify on an issue that's already received a fair amount of discussion, the important distinction between the waiver consultation process and the established variance process, and why a waiver consultation process should be included in 1202C. And finally, Dave Kuhlman and Chelsea Amira will return to the issue raised by Ms. Ryder with regard to the high priority habitats for native aquatic fish and sports fish management waters. By way of background, the draft statement of basis and purpose lists the following documents in support of these 2 new high priority habitats. It cites to 7 federal land management documents in Table 1200-1. It references 7 studies in footnote 26 regarding the importance of intermittent and ephemeral streams. And it refers to 11 pieces of literature regarding aquatic setbacks in 1200-2 table. With regard to the 7 management documents in Table 1200-1, Mr. Kuhlman will testify that none of the listed land management documents establish or support the proposed 500-foot buffers for these 2 high priority habitats, and that all of the listed documents allow for waivers from the limited buffers that are established. Mr. Kuhlman will also testify that the 7 studies listed in footnote 26 do not support the proposed 500-foot buffers for these 2 categories of fish. Finally, the studies cited in Table 1200-2 also do not support the proposed buffers for several reasons. First, many of the listed documents in the table, as is evident from the table, do not recommend buffers at all, or recommend buffers of much shorter distance than 500 feet. Second, with respect to the other documents listed in the table, 2 list ranges of proposed buffers up to 700 feet 750 feet from sensitive wetlands areas. But notably, these documents allow development within the 750-foot buffer area, allowing up to 25% of that area to be developed. These are not no surface occupancy buffers. And finally, a number of the remaining documents that propose larger setbacks need further explanation. For example, one study by the Vermont Agency for Natural Resources is listed as recommending buffers from 10 to 840 feet. But in fact, the document does not make any recommendation regarding buffer widths. And the only reference to 840 feet in the document refers to, quote, the average distance of blue-winged teal nests from the water. Thus, the study is not recommending a buffer at this distance, and at any rate, it is unclear why this reference to a blue-winged teal is at all relevant to the appropriate distance for a buffer with regard to native aquatic species and sports fish management waters. Another example, the table lists a document entitled Wetlands in Washington State as recommending buffers up to 1,900 feet for amphibians, but I do not believe this is accurate. The document and its appendices contains an exhaustive list of proposed buffers in different studies, all of the range between 50 and 300 feet, and the latter to be used only in exceptional circumstances for the most sensitive wetlands and riparian areas that provide the highest functioning level for habitat. There is no recommendation anywhere in this document for a buffer of 1,900 feet in the document. In sum, we do not believe the draft statement of basis and purpose contains sufficient evidence, or really any evidence, to support the 500-foot no surface occupancy for native aquatic species conservation waters or sports fish management waters. And certainly there's no showing that these two NSOs are necessary or reasonable. And thank you for your time. I will now hand it off to Lindsay Ryder.
Thank you. Good afternoon. My name is Lindsay Ryder, and I work for Caris Oil and Gas as the Environmental Health and Safety Manager. I'm a third-generation native Coloradan who grew up in Western Colorado. I have worked in the Piceance Basin for the last 13 years. This is my backyard, and I believe that responsible development can occur while protecting and conserving the natural resources that Colorado has to offer, and I'm deeply committed to that endeavor. I will be discussing the proposed language in 1202C, and specifically, operators will not conduct any new ground disturbance in high priority habitats listed in 1202C. This no surface occupancy, or NSO, is a significant shift from the current restricted surface occupancy, or RSO designation. I will provide a few examples of where I believe that a waiver or exception to the NSO would be more acceptable and appropriate in consultation with all applicable agencies. Caris believes that the Commission should ensure that any NSO included in 1202C have a process by which the NSO can be waived by CPW following consultation on a site-specific basis. A pre-application consultation process with CPW is well established in Colorado and should continue to be provided. We agree that the consultation waiver process provided by API Colorado is much more appropriate than the established 502 variance process. Mr. Martin will discuss this further in a few minutes. Next slide, please. First, I'm going to discuss raptor nests. Caris requests that CODCC allow for a waiver or exception process when nests are unoccupied, inactive, or absent. We believe that it is imperative to allow for development and operations when certain habitats are vacant, either seasonally or long-term. Therefore, a waiver criteria should be established for unoccupied nests. If, through monitoring and scientific survey data, it is determined that a raptor nest is inactive, unoccupied, or absent, exception criteria should apply. We support the response that was submitted by the Energy Council that details this concept further. Additionally, Caris requests that the Commission consider timing stipulations instead of prohibiting surface disturbance in buffers listed in 1202C. As mentioned, nests are only occupied seasonally, typically in the spring and summer months of the year, and operators have historically avoided any ground disturbing activities during nesting time periods stipulated by the applicable agency. I'm providing the following example to demonstrate how timing restrictions have and can work to adequately protect the species of concern. Caris proposed a well pad that fell within a half a mile buffer of a golden eagle nest. This location is on BLM surface, and because golden eagles are federally protected species, consultation with the U.S. Fish and Wildlife Service was required for the proposed action to occur. The seasonal timing restriction went from December 15th to July 15th, allowing 5 months to drill 30 wells. CARES elected to employ 2 drill rigs to meet this requirement and get the work completed within the window that was approved. Sound monitoring data was collected throughout and was provided to the agencies involved as additional mitigation for the project. The golden eagle pair continue to return to this area year over year to nest and raise their chicks. This is just one example of how coordination with the applicable agencies can work to develop these resources responsibly without having a negative impact. There are many examples just like the golden eagle case to demonstrate how timing restrictions have and can work to adequately protect the species of concern. We should rely upon the species specific protocols that have been established by CPW, BLM, U.S. Fish and Wildlife Service, and U.S. Forest Service, and the site-specific consultation process to determine when and where and when timing restrictions would be applied, rather than default to the blanket and strict NSO. The biologists within these agencies have dedicated their careers to protecting wildlife and have the tools and resources to diligently assess the direct and indirect impacts of any proposed project, not just oil and gas, that may fall within a sensitive or critical wildlife habitat. We ask that you consider this example and allow for a waiver or exception to the NSO with time restrictions in consultation with the applicable agency rather than implementing the strict NSO. Next slide, please. Next, I'm going to discuss the aquatic 500-foot NSO buffers. Currently, 1202C is proposing a 500-foot NSO buffer in cutthroat trout designated crucial habitat, native aquatic species conservation waters, and sport fish management waters. CARES requests that the COGCC maintain a 300-foot cutthroat trout NSO buffer and allow for a waiver or exception process in consultation with the applicable agencies in lieu of a strict NSO. I'm providing the following information as an example of successful and responsible development within the proposed aquatic buffer zones. Within the North Parachute Ranch, there are 3 main forks of Parachute Creek, the West Fork, Middle Fork, and East Fork. The drainages within West Fork and East Fork are intermittent and only flow in the spring. As you can see in the photo on slide 2, the Piceance Basin topography has extreme terrain. The valley bottoms, as shown in this photo, can be as narrow as 500 feet across, and near vertical cliffs rise 1,200 feet to the top of the Rome Plateau. CARES consulted with CPW and BLM and employed our wildlife mitigation plan. We implemented mitigation MBMPs that were agreed upon prior to development within the North Parachute Range. Between the years of 2006 and 2016, 60 locations and 670 wells have been developed in these 3 aquatic buffers. These locations were selected in consultation with CPW and BLM. These locations were placed in the bottom of these canyons in areas that were nearly flat to avoid disturbance on the steeper and unstable slopes. These decisions were made with the protection of all environmental resources in mind. For every location within these buffers, we follow our CDPHE stormwater management plan and employ at least 3 layers of stormwater BMPs. We conducted biannual macroinvertebrate sampling by third-party biologists. We allow CPW to collect fish samples annually. We also conduct internal quarterly surface water samples throughout the NPR to monitor for any potential impact. There have been no spills or releases that have reached these surface waters. There have been no stormwater discharges from our disturbances that have reached these surface waters. There have been no impacts to these water resources since development and monitoring began in 2006. I'm sharing all of this with you to demonstrate that responsible development can occur within these buffer zones in cooperation with CPW and/or BLM, and again ask that you reconsider the need for establishing an NSO within the aquatic buffer zones when we as the operator can clearly demonstrate that with the proper protections in place, wildlife resources can be protected. We request that you maintain the current 300-foot cutthroat NSO buffer and allow for a waiver process in consultation with the applicable agencies. Next slide, please. Next, I'm going to discuss the Greater Sage-Grouse 1 Mile NSO buffer. CARES requests that COGCC maintain the current 0.6 mile greater sage-grouse select buffer and allow for a waiver or exception process in consultation with the applicable agencies in lieu of a strict NSO. The proposed NSO buffer is being increased to 1 mile. This is an increase from 724 acres to 2,010 acres per LEC. This one restricted habitat buffer increase is nearly triple the amount of land that would be restricted from development as shown on slide 5. The yellow layer you see is suitable sage-grouse habitat, which occurs along the ridge tops. The valley bottoms do not contain suitable habitat. You can see the local terrain features in the elevation profile, showing the valleys between the ridges. Next slide, please. There are many areas where the NSO for the proposed 1 mile buffer extends beyond and outside of the actual greater sage-grouse habitat. You can see on slide 6 here that the 1 mile red buffer extends beyond the actual habitat, covering an area well below the occupied ridge tops. This would be a scenario where an operator would request a waiver or exception to the NSO buffer, as the area is not within the actual greater sage-grouse habitat. I believe the current consultation requirement with CPW and BLM, as well as existing avoidance, minimization, and mitigation strategies, are providing adequate protection for the parachute Piceance roan sage-grouse population. Because of the extreme terrain features in the Piceance Basin and the PPR habitat utilization patterns along the ridge tops, we believe that the current 0.6 mile buffer is adequately protecting the PPR population. In many cases, the 1 mile buffer goes well beyond the suitable habitat as shown on this slide. At a minimum, we would hope that COGCC can recognize that the PPR sage-grouse population, the PPR sage-grouse utilization patterns are unlike those of the birds studied in Wyoming and Montana. We believe that local consultation with CPW and BLM should be relied upon rather than a blanket 1 mile NSO. In closing, I ask that you ensure that these increased buffers are necessary and reasonable. Consider the consultation process that is occurring with CPW, BLM, and U.S. Fish and Wildlife Service experts, the area and species-specific biologists, and the mitigation strategies that are being employed and that are working. And lastly, and most importantly, we request that your decisions are based on fact, local scientific data, and not on unfounded fears. CARES believes that the Commission should ensure that any NSO included in Rule 1202C have a process by which the NSO can be waived by CPW following consultation on a site-specific basis. Thank you for your time.
Thank you. Can you all hear me?
Yes, we can.
Great. Thank you for your patience. I lost my computer, so I'm doing this on my phone. My name's Kelsey Waselinki. I'm a shareholder with Joe Synergy Law here on behalf of the industry group. I will be addressing 2 issues with respect to the proposed riparian setbacks in the 1200 series rules. First, Rule 1202A3 expands the staging, refueling, and chemical storage area setback to 500 feet from the ordinary high water mark of any river, perennial, or intermittent stream, lake, pond, or wetland. This proposed equipment setback has been expanded from the October 9th draft of this rule, which proposed the setback at 300 feet. We find no basis for any expansion of the 1202A3 setback that cannot be addressed through site-specific mitigation to prevent any impacts to these areas. Furthermore, the statement of basis and purpose cites no support for this proposed equipment setback, nor the expansion of the proposed setback to 500 feet in the latest draft rule. We support the draft CPW waiver language in Rule 1202A, which is also conditioned on final director or commission approval, but we do not believe that a statewide 500-foot equipment setback is necessary or reasonable to protect these wildlife resources. In addition, the terms staging, refueling, and chemical storage areas need to be further defined in the statement of basis and purpose or in guidance to clarify how to measure any setback adopted for these areas. We interpret the intent of Rule 1202A3 to apply to permanent staging, refueling, and chemical storage areas, and not to temporary uses such as a fuel truck, which may be on site for a matter of minutes to a few hours. Therefore, if the Commission is going to adopt any setback to staging, refueling, or chemical storage areas, it is critical that the statement of basis and purpose or guidance identify and define these non-temporary areas so that the proper measurement can be accomplished. Second, I would like to address several parties' proposals for a general riparian setback for all new oil and gas locations. We believe that requests for a general setback to all riparian areas will not result in necessary or reasonable protection of wildlife resources under the mandates of the Act and should be rejected. As other industry parties have and will address in their testimony to you, operators regularly work with CPW and other stakeholders to identify, define, and implement operating procedures to protect critical riparian habitats. Furthermore, as Mr. Mathews addressed with respect to Table 1200-2, there is no evidence in the record justifying such a general riparian setback. We support staff's position that a general riparian setback not be included in the 1200 series rules. Again, we agree that riparian areas should be strongly protected. However, any consideration of a statewide general riparian setback presents several challenges and must take into account the complexities of identifying and mapping these areas and the best available science to support protections of riparian areas. As with Rule 411 and the protection of public water systems, mapping of riparian areas is critical before any setback is even considered. Due to land use impacts such as farming or a change in the drainage patterns, what was once identified as a riparian area may no longer be a riparian area. Impacts from grazing, agriculture, recreation, and land development have historically transitioned riparian areas to upland areas. The identification of riparian areas is somewhat fluid, making a statewide setback with corresponding mapping unworkable unless the Commission and other agencies are able to regularly update map layers whenever a riparian area changes. Furthermore, any statewide general riparian setback will encompass a vast amount of land, as Mr. Coleman will address with you shortly, without any proven benefit or increase to protection. To overcome these issues, a site-specific approach coupled with consultation will ensure that all riparian areas are adequately reviewed and appropriate and protective buffers with best management practices are implemented to protect critical riparian habitats. And with that, I'm going to turn it over to Jim Martin.
Good afternoon, Chair Robbins, Commissioners. Jim Martin, again, appearing for API Colorado, but also on behalf of the industry group. And today we have a very simple ask of you. Proposed rules 1202A and 1202B contain identical language. It allows operators to consult with CPW and, if that consultation is successful, obtain a waiver from required compliance with certain operating requirements. So 2 points here. First, that waiver is still subject to approval by the director or the commission in the form of a Form 4. And second, this really allows CPW and an operator to tailor an oil and gas development plan to the particular site that is under consideration. Our concern is that proposed Rule 1202C doesn't contain such a provision, and we believe it should. Instead, so far as we can tell, and as the staff has testified today, staff proposed that the operator would have to seek a variance in order to do that kind of tailoring permitted under 1202A and 1202B. There are several problems with that. First, a waiver process encourages collaboration with CPW upfront in the process. We think that's where the effort to identify issues and a resolution that works for everyone ought to take place. Conversely, a variance request would have to be included in a permit application, at least as we understand it, after the fact. That is not a process designed to solve problems collaboratively. Secondly, we believe a variance doesn't really work as an alternative to consultation because it asks the wrong question: why the operator can't comply with the rules for a variance, instead of asking whether the proposed location and BMPs are protective of the environment. Asking that question before a permit ensures the most efficient and protective process. Finally, a formal variance process will impose significant transaction costs that could be better invested in seeking out a positive solution and potentially enhancing habitat. There are other places in the proposed rules where staff embraces a waiver process, and we encourage the Commission to embrace a waiver provision in 1202C as well. And with that, I appreciate your time, Chair Robbins, Commissioners.
Good afternoon, Commissioners. My name is Dave Coleman. I'm a consultant for COGA and West Slope COGA. And I will focus my testimony on the issues we see in 1202C1 RS, which got some attention earlier, and the need for a CPW consultation and waiver for all restricted habitats in 1202C. Next slide. My first focus area relates to the vast amounts of land impacted by just 2 of the 20 restricted habitats in 1202C1, specifically the native fish and the sport fish management waters in R and S. In the statement of basis and purpose, staff largely justifies the proposed 500-foot NSO in 3 areas. Table 1200-2 that Mr. Mathews addressed, in table 1200-1 and footnote 26 that I will address. I will discuss why table 1200-1 and footnote 26 do not support a 500-foot NSO. It is important to note that these 2 restricted habitats are new layers, not including in the existing rules that you heard today. Next slide. First point, this slide shows the areas of land in 4 counties impacted by all 20 of the restricted habitats in 1202C1. Any area not in white are areas of land impacted by these restricted habitats. The next slide shows the areas of land impacted by just these 2 restricted habitats. Let's compare these 2 side by side in the next slide. The left side shows the land impacted by all 20, and the right side shows the land impacted by just these 2. Let's look at the numbers in the next slide. For the 6 counties with oil and gas development analyzed, in these 6 counties, 70% of the total land of area of land impacted by 1202C1 are impacted solely by these 2 new aquatic habitats. Just today, both Mr. Duranlo and Mr. Hulse acknowledged this drastic increase in these areas. And Mr. Hulse acknowledged that the total 6.5 million acres added from these 20 new rules, of those 5.7 million were because of aquatic species. This should be concerning. Mr. Hulse also mentioned there was a 12-month process to develop these 2 aquatic layers that I'm talking about. It's great to hear that a detailed process was performed, but unfortunately, this is the first industry has heard of this 12-month detailed process. I verified with several technical experts from industry over the last couple hours, and no one heard about this process. No one from industry was asked to participate, and no one from industry was given the opportunity to sit down with CPW to go through the results of this 12-month process for us to better understand their technical methodology. Nor does this study appear to be mentioned anywhere in the statement of basis and purpose. As a regulated community, this could have helped address or at least reduce some of the concerns that we find ourselves testifying to today. Additionally, Mr. Ackerman testified today that some species in 1202C had little to no data available. Technical experts from industry and other stakeholders like the BLM could have helped with this. Next slide. My second point is we performed analysis on the 7 federal field officers that staff referenced as justification in table 1200-1. We also analyzed the other 7 Colorado BLM field offices not included in this table. We felt we needed to do that to get a full understanding of how the BLM in Colorado regulates these areas. Next slide. There are 3 key takeaways from this analysis of these 14 federal field offices. 1, none of these 14 offices have established a 500-foot NSO from the species included in 1202C1 R through S. None of these 14 offices took a one-size-fits-all approach within their planning areas and held detailed stakeholder outreach prior to finalizing. 3, all of these offices allow for waivers from established NSOs. More on that later. Next slide, please. As stated, none of these 14 offices established a 500-foot NSO. Specifically, 4 of them do not implement NSOs for aquatic species or riparian areas. Rather, they manage these areas through various controlled surface use requirements, management strategies, and timing steps. 2 offices have an NSO, but only for the perennial and intermittent waters and riparian areas themselves, and not for land adjacent to them. 3 offices have a 325-foot to 328-foot NSO for only perennial waters and riparian areas, but then impose smaller NSO of 50 feet for intermittent or ephemeral streams, or address those through controlled use surface use requirements. 3 offices have a 100-foot to 328-foot NSO for both perennial and intermittent streams. 1 office does have a quarter-mile NSO for perennial streams. This NSO, however, applies to up to at most 7.3% of the total land area in the planning areas. And in 1 office's RMP is in draft format. Next slide. My last point on this is that we performed analysis on the 7 scientific studies referenced in footnote 26 of footnote 26 of the statement of basis and purpose relating to the importance of intermittent and ephemeral streams. First off, we agree that in many cases, intermittent and ephemeral streams are important, but our analysis showed that none of these 7 studies recommended or even hinted at a specific NSO buffer, and certainly did not suggest a 500-foot NSO for intermittent streams. In fact, several of these studies advocate against the one-size-fits-all approach and supported further study. Next slide. This table is a brief summary of the analysis on these 7 studies. West Slope Koga's response statements discusses this analysis further, but as you can see in this table, many of these studies suggest some form of additional work, additional study, and none recommend establishing NSOs to protect intermittent or ephemeral streams. Next slide. We have a preferred ask and secondary ask that are a little bit up in the air now based on this morning. The preferred ask was to remove the native fish and the sport fish management waters from 1202C and replace with the following 3 proposals that will ensure these species and areas are adequately protected using the vast technical expertise at CPW. 1, make gold medal waters its own restricted habitat under 1202C1. These are our most critical waters. 2, create a technical work group led by CPW to further assess and potentially address, as technical data dictates, the species in RNS. We have been asking for this since late July, and it does look like a technical analysis has indeed occurred on this now. 3, while this work group is deliberating, all proposed development within 300 feet of the streams identified in RNS should require CPW consultation under Draft Rule 309E. This will ensure consultations can occur and protections established for these areas, and the distance is more in line with those implemented by the 14 field offices analyzed. If a proposal is not protective, CPW can recommend denial as part of the permitting process, and you all can deny it. We believe this preferred approach will allow for a more comprehensive analysis to be conducted, which will result in a better final product that gains more acceptance from stakeholders. However, if this is deemed not possible, especially given today's developments on the study, we recommend that the 500-foot NSOs be reduced to 300-foot NSOs to more closely align with the federal field offices and CPW's original recommendation. Create a full waiver process for these aquatic species, building on what you already have, and we appreciate what you already have. And include language in the statement of basis and purpose that CPW will commit to reviewing these layers with industry over time to ensure the intermittent streams included are in fact appropriate. Next slide. My second focus area relates to the need for a CPW consultation and waiver provision, including directly in 1202C. Others have already discussed this, and I especially point to Mr. Martin's testimony on this. Next slide. I simply have one point to add. The analysis we presented earlier relating to the 14 different federal field offices, 7 of which staff held up as best management practices precedents in the statement of basis and purpose, show that all 14 of these field offices allow for some level of waivers to establish NSOs based on technical analysis. Next slide. Similar to other parties that just talked, we asked the language similar in rules 1202A and B be added to 1202C, and language tweaked in 309E5C to allow for reasonable waivers from CPW using technical expertise. I'll turn it over to Chelsea Mira now.
Thank you. My name is Chelsea Mira, Executive Director of West Slope Koga. Before I get into my plan statement, I'd like to add to Mr. Kuhlman's address of the 12-month aquatics layers process. We're aware that BLM staff was also not included in the CPW process on the aquatic species layers mentioned in the staff presentation this morning. We strongly believe their resource lead and/or their fishery biologist should have been tapped and should be involved in the future for their very intimate knowledge of the lands they manage. Because of the strong waiver process and existing collaboration, our companies have proudly participated in studies from the mule deer collar project you heard about on Tuesday to funding and habitat development for sage grouse, important plant species, large mammals, and aquatic species. Just this summer, endangered fish relying on the flow in the Colorado River near Grand Junction received a welcome boost when additional water in Rudai Reservoir near Basalt was made available to enhance stream flows during the increasingly concerning drought year. The Bureau of Reclamation, which owns and manages Rudai, announced September 19th that additional water was made available for endangered fish as a result of collaboration among multiple partners. Foremost among those was XTO Energy, who generously donated 5,000 acre-feet of water from Rudai. Also this summer, Karis Oil and Gas released 2 golden eagles on company-owned property, while knowing very well they could nest in an area that would prevent development for a time. As you have just heard from previous presenters, a waiver process is critical to our West Slope operators. You've heard a few of many examples of how waivers have worked and why that refined and well-informed process shouldn't be abandoned. To briefly touch on high priority habitat maps and why the waiver process makes sense, the purpose of the maps from the CPW is to guide site-specific conversations, not to codify or make decisions solely on these maps. There are many other uses beyond oil and gas development that utilize these map resources, and we've not seen decisions made on ski resorts, outdoor recreation projects, or building development made without site-specific visits using these maps as a guide. For instance, the Cameo Shooting and Education Complex, which opened in August 2018, is owned and operated by CPW and falls within bighorn production and critical winter range and mule deer critical winter range buffers. Additionally, a portion of the facility falls within the buffer of these new aquatic layers. The Palisade Plunge, a world-class 32-mile single-track outdoor mountain bike trail set to finish construction this spring, falls within elk and mule deer severe winter range habitat and crosses streams 10 times throughout the project. Because of partnerships, site-specific evaluations, creative solutions, and mitigation strategies, these projects and many oil and gas development projects can be approved. I'd also like to be sure to highlight 2 of many active nests observed by our expert witness, Van Graham. This first in Rulison, where eagles continue to use the nest throughout the construction of a new well pad 0.08 miles from the nest, and here in Debec, where bald eagles have multiple nests 0.06 and 0.09 miles away from the very busy Interstate I-70. We know a thriving and healthy habitat and wildlife is not mutually exclusive of development of any kind, whether that be outdoor recreation, ski trails, shooting ranges, or oil and gas projects. It is important these projects be thought out by experts and that a waiver be granted when those experts agree there are mitigation strategies that lead to successful outcomes. We all have the same goal, to keep habitat and species healthy and thriving. Many of our industry and family members are the hunters and anglers and those who enjoy outdoor recreation opportunities we are proud to promote and support. Industry on the West Slope and throughout the state desire to keep the beneficial relationships with expert wildlife biologists, and a strong waiver process is the path to that end. Timing stipulations and demonstrations of best management practices to protect wildlife resources will allow more research, studies, and partnerships to continue to promote healthy habitats and species. And with that, I believe the presentation is done and we're ready to take any questions.
Thank you to the panel for your presentation. Great, we've got share screen off so we can see everybody. There's a lot of you and some of you are commissioners. So commissioners, for questions this time, would you please raise your hand so that I can make sure I find you? Commissioner McGowan, and then Commissioner Nanjapa.
Thank you, Mr. Chair. Thanks for your presentation today. I'm curious to know, under the current process with CPW, it's a consultation with site-specific requirements in place, and I'm wondering if any of you have ever been told no by CPW.
Ms. Ryder?
Yes,
let me mute, maybe it'll help.
So in our consultation process, We have definitely been asked to move locations. We go out on site, and if there's a critical resource, for example, just this summer, we were evaluating a location that was near a lek, but it was close to the 1 mile buffer, I'm sorry, and we were asked to move it even further. So in that situation, we modified the location. In other situations, we may be asked to do timing restrictions or do additional mitigation, but we're always working with CPW and BLM for that fact to find the best possible location, and if we have to move it, we will.
Commissioner McGowan.
Thank you, Mr. Chair. I'm curious to know if you all think that there are some circumstances under which it should be a hard no.
Can I take
Ms.
another?
Ryder?
Yeah. We would never propose a location that we would get a hard no. We know what would produce a denial. We know what the rules are currently, and we would never put a location on top of a lek because we know that is not going to get approved.
Just to add,
Commissioner Nanjap.
Sorry, Mr. Chair. Just to add,
Mr. Coleman.
Sorry, Mr. Chair. Just to add to that, Commissioner, what Ms. Ryder said, part of this consultation process that we're envisioning is the CPW on a site-specific basis could do just that, could do a hard no through that site-specific analysis. And then that would force the operators to move the site. They wouldn't be able to do that because that would become a forced no when if CPW through the consultation says, you know what, this is not protective.
Commissioner Nanjapa, I believe the floor is yours.
Thank you, Mr. Chair. Related to what Commissioner McGowan just asked, and I have another question as well, but has there ever been an instance that the conditions that CPW asked you to put on to the site or the move that was recommended resulted in you abandoning that site altogether or that area?
Yes, we had a couple of locations that were proposed very close to some sage-grouse leks this summer that we, because of the potential restrictions, we did take them off the table.
Commissioner Nanjapa.
Thank you very much. I appreciate that response. And the other question I had was related to the intermittent and ephemeral streams. We've heard in your testimony and in the statements that you provided about the amount of acres that are affected and your ability, to develop is restricted. What I'm wondering is, do you have a sense of how many of those streams overlap with the oil and gas plays? And, given that we also heard this morning that there's a relatively small proportion or perhaps about half of the streams that are in that intermittent and ephemeral categories. I'm just kind of curious, if you can refine that area of impact a little bit more for us based on where the actual oil and gas plays are.
Ms. Ryder.
I think that Mr. Kuhlman may be the
Mr. Kuhlman.
one to start on this one.
Mr. Chair, I'll start. Lindsay, you can back me up for sure. Commissioner, when we looked at those maps that I showed those 4 counties, and they were blanketed with those 2 habitats, aquatic habitats. Those are in the heart of the Piceance Basin, Garfield County, Mesa County. So I'm not going to be able to say a number or a percentage of oil and gas locations. That's something that we would need to collect from all operators. But what I can say is those are significant impacts right in the heart of the Piceance Basin natural gas play.
Yeah, and just to add to that, Commissioner Nanjapa, if I may, I think that we've seen through these layers the disproportionate effect that they have, those aquatic layers on our western slope operators versus the statewide level.
Commissioner Nanjapa, did you have follow-up?
I do not, thank you.
Commissioner Messner?
Thank you, Mr. Chair, and thank you for that presentation. Couple of questions. I'm going to jump around here just a little bit, but since we're kind of talking about the consultation process and some of the comments around that, let me ask just a couple of clarifying questions here. So, Mr. Kuhlman, you had brought up some slides that indicated that there were 14 different BLM field offices that utilize, an analysis. Use their resource management plans don't support the setbacks that are provided within these rules. I wonder, in those field offices, do you know when those resource management plans were updated? Because many of these resource management plans can be 20, 25 years old.
Thank you, Commissioner. Many of them, I do have somewhere in one of our submittals on a few of them when they were updated. There were a lot of them that were 2015, 2016, 2018. There were a couple that were in the 90s, back when I had hair. But 2015 and on were some of the more significant ones. And I don't know, Lindsay, if you have a little bit more info on that, but they were not all outdated, Commissioner Messner.
No, and I wasn't suggesting that. I guess I'm asking if you could provide that information in the future as far as when those resource management plans were developed, and that would help, I think, fill out some of the information that you're trying to provide there. So if that's possible, that would be great.
That's a good suggestion, Commissioner.
Mr. Mathews, did you want to weigh in on that answer?
Yes, thank you very much. We certainly will get you that information, Commissioner Messner. I do want to point out that those 7 of those land management documents are part of the draft statement of basis of purpose. I mean, they were presented by the COGCC as evidence for the aquatic and sports management process, with which there are no waivers. So we didn't select those 7 or those versions of the 7 RMPs. They were part of the administrative record as selected by the agency.
And I appreciate that. I was just trying to get the full amount of information that was provided there. And then I'm just trying to understand, Mr. Coleman, if you could help me with this too, because it seems like you're suggesting that kind of more of a NEPA, EA, EIS process may be more appropriate for looking at species and potential impacts to species that could take potentially years over the process that's being proposed.
Yeah, thank you, Commissioner. No, I'm definitely not proposing a NEPA type analysis on these. And it depends on the preferred approach versus the kind of secondary approach. But the preferred approach, what we were saying, what I'm proposing is in the interim, create a 300-foot buffer around all of these streams that have been identified in 1202 C1 RNS, and make those mandated consultation areas. Whereas if you want to develop in any of those areas, you have to talk to CPW and you have to talk to their technical people. And they have every right, as I said earlier to Commissioner McGowan's question, they have the right to recommend denial. And then of course you all will probably deny it if they did. But while we're going through that over the next however long it takes to do a detailed analysis on these map layers and the streams within them and see, are they truly supportive of aquatic species? I don't know how long that would take, but I learned today, Commissioner, through the staff presentation, and I'm glad it's been done, that it sounds like some of that analysis has already been done. And if that's already been done, maybe it won't take as long, or maybe it'll give us more comfort on what those are. The issue is, Commissioner, what we see is such a huge impact, such a huge increase in impact, especially related to the other 18 restricted habitats in 1202C1. It raised a huge red flag to us, and it was concerning that, hey, do they have this one right? And that's why we've been pushing for a technical work group to study this from all the way back in late July. And so that's what I'm proposing. Definitely not proposing a NEPA style approach, Commissioner.
And thank you for that. I appreciate that. I was just trying to get some clarity there. Although I think in order to be able to do site-specific detailed analysis as proposed, and certainly the way that BLM would handle it in determining their site-specific recommendations, they would take on more of an EA/EIS type of analysis or a NEPA type analysis in order to be able to have the information necessary to provide those site-specific suggestions. So there's probably a little bit of a challenge there as far as being able to expect that a consultation process is going to be able to provide the same level of information that a BLM analysis would. Is that fair to say?
I mean, yeah, if you're on federal minerals or federal surface, yes, you're going to obviously have to do some form of NEPA analysis, which is very detailed. But they address them in their RMPs where they allow for waivers, they allow for exceptions, they allow for those consultations early on. And I think we're just asking for the similar type of stuff related to consultations and early identification of issues for these, rather than a hard 500-foot NSO from those many streams that you saw in that map that I showed.
Understood. So speaking of the waivers piece versus the variance piece, and this may be for you, Mr. Martin, as well as anyone else, but I mean, in the proposed rules, utilizing a 502 variance, it would require CPW consultation. Is that not correct?
That's the implication of testimony this morning, yes.
Okay. So understanding that the variance process as proposed does offer CPW a consultation, and many of the things that I think I'm hearing from folks as far as a site-specific analysis would occur with that CPW consultation through a 502 variance process. Is the major hangup between the variance process and a waiver process that the variance process is just harder?
Mr. Martin.
Thank you, Commissioner. No, that isn't at all a part of the calculation. I think what you heard from staff this morning is that there's a very heavy emphasis on planning at the front end. And I think a couple of the quotes putting them together is that there's a strong encouragement for early engagement and location analysis to achieve the best outcome for wildlife. And it's hard to understand how an operator could seek a variance before having submitted an oil and gas development plan. It's just intellectually, it's hard to imagine how that would happen. So it's going to happen at the end of the process where you're asking a very different question than what's best for wildlife and the environment. So we agree that it's important to encourage that consultation at the outset, early in the process rather than late in the process, because if you're going to tailor an oil and gas development plan, as Ms. Ryder has explained, you can't do that once the oil and gas development plan is submitted. Getting it done early and getting either the buy-in from the CPW or their denial is going to permit the operator and CPW to plan at the outset rather than waiting until much later in the process.
So last question, I appreciate that. So it's not the difficulty of it, it's the timing of it. So if we took the same variance process and moved it into a planning phase versus the timing that it's in right now, would that alleviate your concerns?
No, because I think you're still asking the wrong question. The question ought to be, is there a way to do this that is good for wildlife and the environment and perhaps even enhances the habitat? A variance process just asks whether or not an alternative complies with the rules or doesn't comply with the rules. It's a different inquiry, a different question, and a different process. So I guess the answer, with all due respect, is no.
Okay, thank you.
Commissioner Nanjapa.
Thank you very much, Mr. Chair, and thank you all for those responses, and Commissioner Messner for that question, or those lines of question, that line of questioning. I had a couple of related pieces to that you all sort of touched on, but I just wanted to get a little more clarity. So, Mr. Kuhlman, you mentioned that if we went to the 300-foot buffer for all of those areas with automatic consultation, you mentioned the right to deny still exists. I assume you would also accept if there was a greater buffer proposed by CPW in that consultation process. And what I'm wondering is, you know, you've all sort of spoken a lot about certainty, and doesn't that sort of, doesn't a clear setback give you more certainty than having to adjust your approaches site by site, you know, as you get into these consultations? I'm just kind of curious if you could give me a little bit more, a better understanding of that, of how that creates more certainty than knowing that you have to be 500 feet away.
Mr. Coleman.
Thank you, Chair. Thank you, Commissioner. First off, I just want to say we really believe 300 foot is the right number based on our analysis. So, but yes, if it's something different, 309 is clear that CPW has the right to do a recommendation of either way, and then it'll come to you all, and then the operator would need to have to fight that. As far as the certainty and the clarity, the issue with riparian areas and some of these aquatic species, especially intermittent streams, is a one-size-fits-all approach in this area. They're so across the board on intermittent streams and riparian areas that it actually will provide less certainty by having a hard setback rather than a site-specific analysis. And what I mean by that is an operator can go to a site and say, okay, there is something that is on the map in intermittent stream, but they can go to it and say, oh no, there's no way that they can, there's no way that intermittent, what's classified as an intermittent stream, can support aquatic species, or there's no riparian areas anywhere around it. So we can then say, okay, we can permit this location. We can try to permit this location because we ground truth it. We're right on location, and there's no issue. Whereas if we go to another location where you have something classified as an intermittent, and we see water flowing in June, and we see species of fish in there in June, we're like, this is going to be a problem. So I would argue that you're a little bit more, you get a more certainty with the site-specific analysis in this case because of the uncertainty of intermittent and riparian areas. I think Mr. Mathews wanted to tackle.
Mr. Mathews.
Yes, I'll just piggyback on that quickly. Commissioner, I think you've heard from Ms. Ryder, and this is something we hear from all of our operators. They prefer the certainty of a process that makes the determination early on. Ms. Ryder gave some examples of some sites where CARIS moved the location because they found out early on, pre-application, that CPW wasn't going to recommend approval. That is far preferable in terms of certainty for operators than the variance process that Mr. Martin just walked through, where now operator's not going to know until after a hearing, after an application submitted, when the operator has to show that it can't comply with the law. A different question than the CPW consultation process asks, what is best for the species? So the matter of certainty is really tied to timing and process here, Commissioner. Thank you for the question.
Ms. Miera, did you want to add?
I do have just one last little piece, and I know it was alluded to in our written testimony, but when you look at the Piceance Basin, you have to really consider the rugged terrain that we deal with as well, and that locations that might look on a map like they are 30 feet apart really are ridge top to ridge bottom, and that truly does make a difference as we go and evaluate these sites.
Commissioner Nanjapa.
Thank you very much, and to all of you for those responses. That helps in sort of understanding where you're coming from. I'm wondering then, based on, you know, some of the things you've said, and given that there have been these instances where you've had to vastly change, you know, the location or maybe even give it up altogether, so are you basically saying that you would prefer more of a pre-consultation requirement?
I'll let Ms.
Mr.
Ryder speak for
Mathews,
operators. Excuse me, Chair Robbins, I apologize.
Go
Yeah,
ahead.
I would be happy to answer that. We already are doing that with our wildlife mitigation plans that have been in place for the last 10 years. We are doing consultation with CPW on every single location that we develop. So I don't know that it requires a requirement per se, because it is being done.
Mr. Mathews, did you add?
No, Ms. Ryder said it better than I was going to.
Can I answer? I would like to just loop back really quick. Another reason that the buffers, those that we're looking at, is it's not just that you know, the buffer is set and we can have certainty that that buffer is there. Really what we want you to recognize is sometimes the habitat doesn't exist or it's not suitable for the species. So in those situations, we would like to have that on the ground conversation with CBW or BLM where they can acknowledge or confirm, yes, the habitat is not suitable for sage grouse, or yes, the species of concern is not actually here. You wouldn't need to have that same buffer distance. And that's when we would use a waiver process.
Commissioner Messner.
Thank you, Mr. Chair. So I appreciate that. I guess I'm still a little confused because I'm hearing the timing's an issue. I'm hearing that the questions in a variance aren't the right questions to be asking. It's a consultation question. What I'm hearing you say, Ms. Ryder, is that you are consulting with CPW prior to applications so that you're determining the right place. And if there is no wildlife in a particular habitat, or the habitat's not there for whatever reason, that would create the opportunity to make a compelling argument for a variance. So I guess I'm struggling to see what the problem here is.
I think that we just believe that a pre-consultation waiver process similar to what is mentioned in 1202A and B is appropriate for 1202C as well.
Ms. Ryder, but there is a consultation in 309E3C, I believe, and I may have that wrong, that you will be doing early on. Does that not provide some outlet? And Mr. Martin, this is a question to you too.
I'll defer first to Ms. Ryder if she'd like to go first.
I think that if that results in the outcome of us being able to obtain a waiver or exception in the 1202C buffers, that is what we're looking for.
And let me just ask kind of a follow-up. So you go to, using 309, you do your consult, CPW kind of gives you the, this is going to be good, even though it's within one of these proposed NSOs. Is it, and Mr. Martin, this may be for you, is it that that's not enough to then go do all the extra work and file the OGDP with the hopes that the commission is going to grant the variance at the end of the day? Is that kind of the question?
So I have an embarrassing admission to make, Chair Robbins. I was referring to my notes while you were speaking, and so I didn't catch the first part of your question. I apologize.
I was just, so there is this consult under 309, and say you do that, and CPW says that, we're going to support the variance request. My question is that unfair, because you then have to go do all your planning and get your permit together, and then with the hopes that the commission at the end of the process is going to say, yep, we're going to give you a variance.
That's precisely right, Mr. Chair Robbins. Although
Commissioner?
I continue to believe that a variance asks the wrong question again, that the question ought to be, does this work? Can CPW and the operator and ultimately the commission come to some agreement that in that particular situation, a waiver is appropriate, rather than the question of whether or not it's consistent with or violates the commission's rules.
Okay, thank you, Mr. Martin. Commissioner Gonzalez.
Thank you, Mr. Chair. No, I see where you were getting at there, at least I think I do. And I guess my follow-up question would be, under a waiver process that allows the commission to approve an OGDP subject to a waiver from CPW, that's one thing, right? That's pre-consultation. That's kind of what we've been talking about. Now, if that happens prior to an OGDP, and then as Chair Robbins says, CPW gives you the thumbs up, hey, this location is going to be okay, and then you have to go through the variance process. Are there any additional burdens that you have to go through in the variance process? Any additional elements that you have to prove?
Mr. Martin.
If I might, Mr. Chair or Chair Robbins, I'd like to defer to Mr. Mathews because I think he's more familiar with the variance process than I am, although I'll just return to my mantra, Commissioner Gonzalez, and say that I guess two things. One is I'm not sure if the CPW is in fact granted a waiver in writing, why the commission would have to go through the waiver or the variance process at the end of the day. That seems to be a belt and suspenders kind of approach to this question, and that it would be simpler and easier and more consistent with the process if the commission just decided it would or would not grant the form for a waiver. But beyond that, I continue to believe that a variance process continues to ask the wrong question, which is whether or not a particular request is consistent with the commission's rules or not. And a waiver process gets you out in front and asks the question of whether there's a solution that is acceptable to all parties and that it protects and even enhances the wildlife resource, whatever that might be.
Mr. Mathews.
Yes, what Mr. Martin said is accurate, Commissioner Gonzalez, and thank you for the question. There are series of questions that have to be answered in the variance process. Some of them are, is this protective of public health, welfare, and safety? Does it fall within the intent of the act? Those are the questions that CPW will be asking in the pre-consultation process. And if we have a waiver process, the commission would be asking pre-application. But in addition, to get a variance, you have to, because variances arise in very different circumstances. We had this discussion during the 500 series, when an operator cannot comply with the law or the regulations and has to show why it can't comply with the law and why it made a good faith effort not to comply with the law. And it does so in a full-blown trial setting, if you will, administrative trial setting, subject to the entire litigation process, administrative litigation process. Commissioner Nanjapa asked the very appropriate question regarding certainty early on, and I indicated it had to do with timing. What does that add to this process apart from tremendous transactional costs? And the answer to a couple of somewhat irrelevant questions about why the operator can't comply with the law, when the key questions, is this good for the species? Is this protective of the species? Everything that we heard today was important to CPW with regard to 1202C is answered early on in the consultation process, both by CPW and by the COGCC staff. So I struggle to see why there has been such resistance to incorporating this waiver process into 1202C. It should be as protective. It just gives operators a much better chance to pull back proposals that won't work and propose something that might, and perhaps in an alternative location. And the full expectation in response to several of the commissioners' questions is denial will be recommended in a number of circumstances by CPW, and the commission will deny applications and during the pre-application waiver process. But at least operators will know prior to having to file an application, having to go through the entire waiver process, variance process. Forgive me if that was a little attenuated. I hope it got to your question, sir.
Are there further questions for this panel? Scanning the room, I'm not seeing any. So thank you all for your presentation. If you could ensure that your slideshow makes its way to our staff, that would be helpful. And again, we appreciate your participation with us on these important matters. So thank you.
Thank you very much for your time.
We now will turn to Adams County for a 5-minute presentation. Everybody give us a sec while we remove some people and add others to the presentation. Ms. Fitch, are you presenting today, or do we need to find Mr. Dean?
Mr. Dean just texted me and said he's not in all caps. So he's here somewhere on the participants list. Maybe we can have him raise his hand or add something in the chat.
Yeah, Mr. Dean, why don't you raise your hand or chat us? There he is.
Hey. Once he gets his video working, I'll have, there he is. I'll go ahead and share my screen. All right. Hopefully everyone can see that. Good afternoon, commissioners. You already know Greg and I, but my name is Christy Fitch. I'm an assistant county attorney for Adams County. We are here to present some pretty minor changes to the 1200 series rules. The county is largely supportive of the 1200 series rules as presented, but we do have some changes that we think would help with the process with working with relevant and proximate local governments. So given that, I'm going to pass it over to Mr. Dean to explain our requests.
Thank you, Ms. Fitch. This is Greg Dean, Oil and Gas Liaison for Adams County. I would like to first thank the Commission and staff and all the stakeholders for their diligent work during this rulemaking process. Adams County recognizes CPW as the state agency with the most expertise in avoiding and mitigating wildlife impacts, and we intend on heavily referring and relying on that expertise in the application and enforcement of the 1200 series rules. The county's primary request is for expansion of local government consultation and notification requirements throughout the wildlife protection rules. Senate Bill 19-181 gave the county the authority to evaluate and cite oil and gas locations within its jurisdiction, and we believe the limited reference to local government in the proposed draft rules and statement of basis and purpose does not fully satisfy those intentions, tenets, or requirements. The county's request for added reference to local government consultation is in the spirit of interagency coordination and a more holistic approach to permitting, and is not intended to impede, reduce, delay the ability to assess potential impacts to wildlife and apply and enforce those applicable rules. As it pertains to ALA requirements with CPW, the county agrees with the notion and position of staff as presented in the draft statement of basis and purpose and the FAQ document that the most efficient mechanism for avoiding high priority habitats is to coordinate with operators during pre-application. We argue that any consultation with CPW regarding the identification of alternative locations or the alteration or relocation of a proposed pad site, access roads, or other infrastructure for the purpose of avoiding or mitigating wildlife impacts must explicitly require the inclusion of relevant and proximate local governments, rather than only encourage such interaction as presented by staff. We request a pre-application consultation provision similar to the one approved between local governments and the COGCC in R301F3 be included in the rules that would allow local governments to request consultation with CPW early in the local permitting process, and more importantly, that such could serve as a partially or fully comply with the consultation requirements of the Commission Rules 304 and 309. To facilitate this request, the county supports the proposed increased duration of such consultation from 40 to 60 days pursuant to 309 E4B. Our request is regarding the process of consultation and its implications on land use authority matters, and not on identifying specific wildlife impact concerns. This will help ensure protection of wildlife resources and maintain the shared regulatory authority, while also limiting or avoiding duplicative and conflicting processes in instances where a local permitting decision has already been rendered. Next slide, please. The county further argues that relevant local government must be consulted and maintain final authority regarding revegetation and seed mixes used for interim and final reclamation pursuant to 1202A6. Adams County Development Standards and Regulation require county approval for seed mixes associated with various project types, including reclamation, site stabilization, revegetating in wetlands and environmentally sensitive areas, and as erosion and sediment controls. Further, seed mixes and reseeding plans are evaluated by the county as part of the production plan included in our oil and gas facility permit process, and includes robust interdepartmental and external review. This consultation would ideally occur early in the permitting process and could be included as part of the county's request for pre-application consultation provision referenced previously. Again, the purpose of this request is to further expand coordination and ensure local governments maintain the appropriate level of land use authority and control. Next slide. Lastly, the county supports the efforts of the COGC and CPW to mitigate adverse impacts to wildlife via compensatory mitigation provisions presented in 1203. In line with our previous asks, we request local government consultation as part of the review of compensatory mitigation plans pursuant to 1203B1 prior to the assignment and initiation of such projects. The purpose is to ensure these projects compliance with all local government land use regulation and compatibility with the county's comprehensive master plans. The request is not intended to limit or reduce the ability of CPW or this commission in determining when such compensatory mitigation is necessary or required, or to further limit your ability to determine the location, scope, scale, or geographic extent of such projects. The county has been truly honored to be welcomed as an active stakeholder during this entire process over the last year, and we look forward to building and expanding on our relationship with this commission within the new cooperative and co-regulatory framework advised under Senate Bill 19181. Thank you.
Thank you, Mr. Dean. Thank you, Ms. Fitch. Do we have questions for this panel? Commissioner McGowan.
Thank you, Mr. Chair. Thanks for coming in again today. We're in the final stretches. I'm wondering if you could, I think I'm a little confused about the local government consultation for the mitigation plan. If the mitigation involved city or county owned property, wouldn't CPW have to consult with you anyway?
I'll let Ms. Fitch address that question.
I do believe, yes, if it does, I apologize if you didn't see my cat decide to Zoom bomb me. She's also making a lot of noise right now. So the county, if it did involve county-owned land, yes, we would be an active group in that and be required to be consulted. I believe our ask here is just to be consulted on those properties where we don't own the land, right? And it is going from an alternative location analysis where CPW is requesting a different location. It's more just a process issue where we just want to be brought to the table, and we intend on bringing in CPW in as well. But as Mr. Dean stated, in Rule 303 with the alternative location analysis in the 300 series, that was expressly added to be adding relevant and proximate local governments. So we would just ask the same on this stage as well.
And to expand on your question, Commissioner McGowan, we've been in contact with our energy liaison at CPW, and we fully intend to start text amendments to our county regulations that would add CPW as a consultation, external consultation party automatically on new county permits. But our concern is, as important as that consultation is at the county level, we would like that consultation to also apply once the permit does reach the state's desk, whether that is concurrent or sequential. We just don't want to duplicate effort here, especially for alternative location analysis. And we understand that moving an access road might really help mitigate wildlife impacts, and we are amenable to that. We just want that to be done before we actually render a permit decision, because it's not as easy for us to fix that problem going forward. We'd have to redo the permit process if they have to move the access road after we've already permitted a location, because that would be considered a major change under county regulation. So things like that. We just want to try to address as many issues as we can up front before it actually reaches COGCC.
Thank you.
Other commissioners with questions for this panel? All right, I'm not seeing any, so thank you again for your presentation today and for your being involved with us on this rulemaking. We really appreciate it. And we will now move on to our next panel, which I believe is Affiliated Local Government Coalition.
Okay. Is everybody ready? Or I guess we need to see if we have our two witnesses on.
Yeah.
Kristen Pritz.
You've got Ms. Pritz.
Okay.
And Therese Glowacki, I'm here too.
You have both your witnesses, Ms. Burke, and we can see and hear everyone. And
All
we
right.
see your screen, so you are good to go.
Amazing. Okay. Good afternoon, Kate Burke with the Boulder County Attorney's Office, and I'm speaking today for the ALGC and for Gunnison County. And we do have two witnesses who are going to give you information to support the 8 requests that I'm first going to outline. And I apologize, I'm going to fly through this to hopefully get it through, so we'll be happy to answer questions if it's a little too rapid. Okay, oops, hold on. There we go. First, we are also still requesting local government participation in the 309E consultation. We acknowledge the Rule 302G consultation opportunity and the pre-consult statement you added into 309E, but we request a seat at the table with and at the same time as CPW, which isn't the case in those other consultation opportunities. As our witnesses can explain, local governments often can fill in and supplement CPW's data and share that information with CPW, the operator, and COGCC in one efficient, effective conversation. So acknowledging that there are the other consultations, we are changing our earlier proposal to request these changes to 309E, bringing local governments into the CPW consultation at the government's request. Not all local governments may want that opportunity. Okay, second, activities that are otherwise classified as routine can still threaten adverse impacts to wildlife, even at existing oil and gas locations. And our witnesses will describe how this has occurred on the ground. So we request a clarification like the one example on the slide to provide a more precise trigger for when consultation is required to ensure wildlife protections. Third, we request, in addition to the statement of basis of purpose, mirroring Commissioner Messner's question this morning about compensatory mitigation vis-a-vis denial. In the context of 181, unavoidable adverse impacts should really be an oxymoron, because every impact is avoidable through denial or a no action alternative. In fact, I noted with some concern that Mr. Duranlo's mitigation decision tree slide this morning left out the possibility of denial where impacts cannot be avoided or minimized. So we just suggest 2 things on this point. First, a semantic change might be helpful from unavoidable impacts to something like resulting adverse impacts. And second, we request an amendment to the SBAP stating clearly that adverse impacts should be avoided and mitigated so thoroughly that the need for compensatory mitigation would be rare and de minimis. Fourth, the compensatory mitigation fee in table 12031 we heard about this morning ignores both smaller scale disturbances and the highly variable kind of impacts that could occur between 1 and 11 acres. Neither the SBAP nor the averaging methodology that was explained this morning adequately explains how $13,000 can always compensate for all possible impacts up from anywhere from 1 to 11 acres. So again, we urge two things. First, please apply the fee to disturbances under 1 acre in size. And second, please consider a per acre fee tailored to the actual disturbance at hand. Fifth, we continue to urge protections, specifically the consultation and ALA, for sites adjacent to HPH due to the unpredictable behavior of wild animals. After discussion with staff, we've reduced our earlier request to a 300-foot buffer outside the defined HPH to ensure that development in those locations will not adversely impact animals in the immediately adjacent zone. Oops. Too many things to. Sixth, we continue to request additions and modifications to the definition of HPH in 1202C. We still support other parties' recommendations on this point, including the Western Biological Resources Coalition, and then our specific suggestions shown on this slide. If lack of good data is the primary reason that some species are omitted from the list, local governments and others are surely able to supplement that data, and our witnesses can speak to that as well. Seventh, we request an addition to 1202A5 requiring that not only open trenches but also open pipes be protected to prevent wildlife casualties. And then eighth, for reasons that our witnesses can discuss further, hazing of migratory birds is not an appropriate methodology and should be eliminated from 1202A8. And then finally, our Boulder County witness in particular will discuss some of the points made by other parties, including the industry group's request for timing restrictions in HPA rather than exclusions, and the importance of riparian setbacks. So I'll now give you to our two witnesses. First, we'll have Kristen Pritz, Director of Open Space and Trails for the City and County of Broomfield, and then Therese Glowacki, Manager of the Resource Management Division for the Boulder County Parks and Open Space Department.
Thank you, Ms. Burke. Good afternoon, Commissioners. Thank you for this opportunity to speak. Broomfield has an environmental review process that covers such topics as wetlands, floodplains, nesting birds, state threatened Tier 1 species, endangered species, and prairie dogs. This review process is helpful in protecting local wildlife and other natural resources. Project sites under 1 acre should still trigger a consultation. The size of an expansion is not the critical issue. Rather, it is the nature of the affected land that may serve wildlife habitat and other natural resource functions. Wildlife can be significantly disturbed by any unaccustomed noise, exhaust, fumes, and both road and foot traffic if it occurs in the wrong place at the wrong time. The actual acreage disturbed is not the trigger. It's the type of activity and the sensitivity of the animals in the land. All disturbances greater than a couple of vehicles passing over existing roads should be presumed to have the potential to disturb some wildlife resources, potentially quite seriously. We had an instance in Broomfield where burrowing owls stayed in their burrows year-round rather than migrating when expected. This is another reason why any disruptive activity must be preceded by consultation and, if appropriate, surveys. Some routine well maintenance and repair activities on existing oil and gas sites should require consultation and include local governments. Broomfield has witnessed situations where significant numbers of vehicles and large pieces of equipment have been involved in routine well maintenance activities, which could negatively impact wildlife and other natural resources. In these photos that are on the screen now of otherwise routine activities, heavy equipment was stored outside the well pad in an area that was home to prairie dogs and burrowing owls. A consultation with COGCC and CPW should have occurred before the equipment was moved into the area due to the threat to important species. We understand the need for well maintenance, that's very important, but it often can impact wildlife and natural resources that should be protected during this process. Thank you for consideration of these comments, and I'll now turn it over to Therese Glowacki with Boulder County Parks and Open Space. Thank you.
Thank you, Kristen, and thank you, Commission, for the opportunity to present to you today. I'm trying to get my screens. There we go. So I am Therese Glowacki, the Resource Manager for Boulder County Parks and Open Space, a position I've held for over 20 years. I'd like to cover 6 topics in the 1200 rules. First, timing restrictions. Timing restrictions alone are not adequate for protecting species in high priority habitats. These habitats provide nesting, migration, and refuge, thus need year-round protection. For example, if trucks or rigs are driving around boreal owl habitat in the off-season, they could permanently destroy the nesting burrows. These birds come back year after year to the same location. So if you destroy their nesting burrows, you're reducing their chance of survival and reproduction in subsequent years. In addition, high priority habitats are not just home to one type of species. Single species protection does not achieve the overall protection necessary to keep a healthy, functioning ecosystem that supports many important plants and animals. Finally, wildlife does not always conform to seasonal patterns we identify for them, so timing alone may not protect them and their habitat. For these reasons, high priority habitats need year-round protection. Second, riparian setbacks. Riparian setbacks are crucial for so many species. About 90% of all birds use riparian habitats at some points in their lives. And recent nationwide surveys have found we in North America have lost nearly 3 billion birds since 1970. That's 1 in 3 birds vanished in the last 50 years. This gives us overwhelming reason to protect riparian areas to the greatest extent possible. During the 2013 flood on county land, we had oil and gas infrastructure located near a creek that was pushed off its foundation in the floodwaters, causing water and soil contamination. With climate change, we expect more intense storms and more floods, increasing this risk. Solid riparian setbacks are essential. Third, identification of high priority habitats, the Rule 1202C, and appropriate buffers. Preble's meadow jumping mouse is a federally listed species and needs to be added to your list of protected species. Preble's mouse is dependent on riparian areas, and habitat conservation plans in Boulder County require up to a 500-foot buffer. This is a necessary protection for this species that only lives along streams. Burrowing owls are a state threatened species that need to be added. Their buffers should include a 1/4 mile during the pre-production phase with large disturbances, and a 1/8 mile during the rest of production. And on the right, what you see here is what others have referred to, including Adams County, that many times it's the local experts like Parks and Open Space that have the most current information on the wildlife values at risk. Northern leopard frog populations are rapidly declining in Colorado. Like many amphibians across the globe, they need to be added as well. Our monitoring shows they are disappearing in Boulder County. It's heartbreaking to watch a species disappear before your eyes. Their stream and pond habitat should be protected. Regarding changing buffers, bald-eagle protections should be no activity within 1/2 mile of a nest. U.S. Fish and Wildlife Service has a 1/4 mile buffer, but in Colorado, with our open plains rather than forested environments, 1/2 mile is more appropriate. The rules should also protect the Gunnison sage grouse, the same as the greater sage grouse, with a 1 mile setback. Oil and gas development is one of the major threats to these unique and declining bird species. Fourth, please add consultation and alternative location analysis for sites within 300 feet of high priority habitats. Because animals may be anywhere in a high priority habitat, this addition will ensure protection when nests are at the outside edges of these areas. Fifth, raptor deterring grates should be required over venting pipes. Burrowing owls and other raptors like to perch on top of oil and gas infrastructure. These perching raptors have been killed when gas is released from these pipes. Please include a rule that requires raptor protecting devices on all venting pipes. And finally, please do not allow hazing birds as a mitigation method. Hazing rather than avoiding nests may result in disturbing birds that are already on nests, and the bird's loss of an entire year's reproduction. Surveys for breeding birds should be done during the nesting season and when a breeding bird is found on a nest, that area should be avoided. Thank you for considering these changes.
Thank you to the panel for the presentation, as well as your involvement with us on the Wildlife 1200 series. At this time, we may have questions. I turn to my fellow commissioners. Are there questions for the panel? Commissioner Nanjapa, then Commissioner McGowan.
Thank you, Mr. Chair, and thank you all for your presentations and your comments. I think I generally understand what your requests are, though I just had a quick question on this, the last bit about the raptor protections on venting pipes. Are there existing kind of exclusion devices or methods that are known already?
Yes, there are. And sometimes oil and gas companies will use them, but it's not mandated anywhere.
Commissioner McGowan.
Chair, thanks for your presentation today. I'm wondering if I'm trying to figure out how we're going to tackle folks wanting additional species added, and CPW's struggle maybe with an appropriate data set to deal with those species. And to your point that sometimes a local government might have information that the state does not. If consultation for local government is earlier in the process when we're dealing with wildlife species, might that help us address any species that are not in the list, because the local government could tell us where they think some important habitat is for some of these species?
Was that a question for us, Commissioner, or for your
Yes.
fellow? Okay. Well, I'll say one thing, and then I'll let the witnesses chime in. So I think that there's I think two parts of that. One is timing, and then also the other one is who's at the table. So under Rule 302G, the new Rule 302G, we assume will be enacted. There is additional consultation for local governments, which does, I think, as AG Minor mentioned this morning, explicitly talk about wildlife. However, what we're suggesting is our participation can be even more effective if we're there with the CPW representatives at the same time, because we may have complementary information, there may be dialogue that results, because as my understanding, and Therese can speak to this better for Boulder County, a county like Boulder and Broomfield, which are very active, may have pretty up-to-date granular on-the-ground information that CPW hasn't collected yet. So Therese, why don't you go ahead with that?
Yes, that is exactly right. And when we're working under the previous rules, we have the ability to weigh in with the surface use agreements. And so we have our staff out there with the oil and gas operator, and sometimes CPW comes along. I think we would like to be included, as was mentioned earlier today, early in the process, and have stronger regulations that do respect the knowledge and the expertise of the local areas. And including, we have universities here that have been doing studies, for example, on raptor nests for 100 years. So stronger rules that allow us to weigh in early, I think, are important.
And I think that the hearing this morning, it was enlightening to me that a big reason for the species, or the way HPH is currently defined, has to do with simply what data CPW has, and they admittedly are missing a lot of data. And I think that's the absolute reason why we would like to offer that expertise that we have. And not all local governments have that, and not all local governments will want that opportunity, which is why we shifted our request to being allow the local government to request the consultation when it's appropriate for that particular jurisdiction.
Ms. Spritz?
If I could just add that I really support what Ms. Burke and Ms. Glocke are saying. We also have very site-specific reports that we have for many projects. And I think that would be wonderful information that we'd like to share with CPW and be involved early on in that process.
Commissioner Nanjapa.
Thank you, Mr. Chair. And again, thank you for your responses to Commissioner McGowan's question, I just wanted to make sure to see if we could put a finer point on what I think she was asking, which is that with the consultation, and given the additional data that you may have, the additional information, could that preclude the need to add a specific high priority habitat designation for the species that you mentioned? And I'm thinking in particular because of the updating of the maps and those kinds of things where your data may be updated more readily. And if there was a consultation site by site, you might be able to get at that perhaps more effectively. So just curious if you could respond to that.
So I'll jump in first and then let Kate add to it. The 3 species that we're asking to be added, one is a federally listed threatened species. It's the only federally listed mammal in Colorado. That's the Preble's meadow jumping mouse. That's why we feel that should be elevated. The burrowing owls are a state listed species and are very common in prairie dog areas where oil and gas is very common, certainly here in the Front Range. And the third one is the northern leopard frog. And as we all know, amphibians are globally threatened. And the ability to have that on the list will help us protect one very declining species in Colorado. So we're not asking for 10 other species. And when we get to the critical wildlife habitats and the local consultation, that's where we have other maps, but that's why I think we want those 3 species elevated. And then at local consultations, we can look at our critical wildlife habitats and those sorts of designations we have.
And I would add, Commissioner, that I would be reluctant to rely completely on the local consultation piece because there will be those local governments that don't have the resources to have the same kind of data that we have or the same level of expertise on staff or that kind of thing. So I don't know how widespread, for example, the leopard frog is, but it may be that those species could exist in places where the local jurisdiction doesn't have the resources to present that in the same way. So that's why we would like to see it on the statewide protective list.
Thank you for those answers. Are there further questions? All right. Thank you again for your presentation and your being involved with us on this important rulemaking. We do appreciate it.
Thank you.
Thank you so much.
With that, I believe we're going to be the change for a 5-minute presentation. Mr. Doe, I believe we've got you as a panelist and it looks like you've unmuted. You have the floor. We cannot hear you if you're speaking.
Mr. Chair, perhaps if Mr. Doe is having technical problems, we could put him back into the Zoom meeting and I can chat with him and we can bring in the wildlife anglers group now.
What about Karis?
Karis has actually joined with industry. I apologize that
So that's
was not
changed on the list. Okay. The wildlife hunting and anglers groups that's a 30-minute presentation, and I know they've got a lot to say. Do we want to take a quick break before we go into that kind of a presentation? I'm seeing heads nodding up and down. So let's take our afternoon break and return at 3:45. And I believe we do have sufficient time to get through the rest of the presentations outlined for today. So see you back at 3:45.
Well,
I see he's still a panelist.
if he is able to. Mr. Doe, if you can't hear us, we are ready for your presentation. Yeah, it unfortunately does not appear that Mr. Doe is going to be able to participate at this moment. But again, we'll keep checking in with him and see if we're able to get him in today.
Yeah, I just chatted with him to see if he could unmute, but I haven't heard from him. So we'll keep trying. Why don't we go ahead and get the next panel in, and we will get started. Good afternoon, Mr. Randall. Let me know when you've got all of your participants ready to go, and then we'll get started.
Thank you, Mr. Chair. It does look like everyone is on. Can you hear me okay?
We can.
Terrific. I'll go ahead and get started. Again, I'm Bob Randall. Good afternoon. I'm counsel for the Wildlife Hunting and Angling Party Group. I'm going to provide a quick response to the staff's October 9th revised draft. Then we'll move into witness testimony. First with a panel on protection of aquatic high priority habitats, and then on protection of big game habitat areas. The staff's October 9th revised draft contained relatively few substantive changes to the 1200 series rules. We appreciate staff's proposed change to expand buffers for aquatic high priority habitat streams from 300 feet to 500 feet. These buffers are necessary to protect aquatic, terrestrial, and avian species that rely on river corridors. We also appreciate the proposal to add bighorn sheep production areas to Rule 1202C to protect this iconic species. We're disappointed, however, in the staff's decision not to incorporate other elements of our proposals, which we will address in and following our witness testimony. One proposed change in the staff's revised draft that deserves specific discussion here is the proposal to require that wildlife habitat maps be updated only through the Commission's rulemaking process. I appreciate the fulsome discussion on the topic this morning, and I heard your Assistant Attorneys General advise you that updating maps through rulemaking was prudent, and they may be right about that, but we submit that it's not required by the Colorado Administrative Procedures Act. The high priority habitat maps are simply a visual and GIS depiction of the high priority habitat areas. They clarify the meaning and applicability of the 1200 series rules, but they themselves don't impose any substantive requirements in addition to the 1200 series rules. Thus, the high priority habitat maps are an interpretive rule, and the APA's rulemaking requirements explicitly don't apply to interpretive rules. That's in CRS 24.4.103 sub 1. This unnecessary procedural hurdle could result in less frequent updates of the maps due to competing agency priorities for rulemaking and, as a result, less accurate maps. In its place, we've proposed the rule language that you see here that would call for a transparent and transparent and inclusive agency process. Key to this process are updating maps no more frequently than once a year, publication of notice and solicitation of input on whether or to what extent maps should be updated, CPW's evaluation of information received from the public, including reference to peer-reviewed literature, publication of notice of any map updates along with CPW's explanation for any changes, and importantly, the fact that modified maps wouldn't apply to any permit applications that had been deemed complete pursuant to the Commission's 300 series. Ensuring that maps are accurate and up to date is critical for protecting important species and habitats, confirming that the requirements of the 1200 series don't apply to areas that aren't actually high priority habitat, and ensuring the credibility and public acceptance of the Commission's regulatory program. I appreciate the discussion just before lunch, as well as Director Murphy's sense this morning that the maps should be updated biennially, annually or biennially. I also appreciate Chair Robbins' acknowledgement that this professional commission has additional capacity to do so that the previous commission might not have had. Should the commissioners adopt staff's language to require map updates to go through a rulemaking, we would respectfully request that the statement of basis and purpose be revised to commit to doing so at least once every 2 years. Now we'll move into our witness presentations. Again, starting with Dennis Beekler, witness for Colorado Trout Unlimited, to discuss the value of wetlands and riparian areas to wildlife species. Thank you.
Good afternoon, Commissioners. I'm an aquatic ecologist, and I've been working on fish and wildlife habitat mitigation issues since 1972. I've also served on the Wildlife Commission, so I appreciate the time that you are putting into active listening. Two of Colorado's most important habitats are wetlands and riparian corridors. They comprise less than 2% of Colorado's landscape, but provide benefits to more than 25% of our wildlife species, including waterfowl and several declining species. Conservation measures implemented in these two habitat types provide the greatest benefits to our wildlife populations. Streams also provide important habitat, especially headwater streams and trout streams. Even streams that do not have year-round flows can provide important riparian habitat. The best way to conserve these habitats is through mitigation sequencing. The top priority is to first avoid and then minimize adverse impacts to the degree possible. Then for unavoidable impacts, habitat values should be restored or enhanced on or near the impacted area, be in-kind habitat, and be done as soon as possible after the impacts occur. Only after exhausting these efforts should project proponents be allowed to compensate for losses through the purchase of mitigation banking credits or by a one-time cash payment. From an ecological standpoint, I have never seen an instance where either of these options proved adequate to replace lost values. The two best ways of avoiding and minimizing habitat losses are large-scale advanced planning in coordination with Colorado Parks and Wildlife and adequate buffer zones. Spill prevention practices are also important, along with adequate berms, especially in floodplains. Thus, we support the consultation requirements in Draft Rule 309, including that CPW be consulted when the agency requests it. I believe that early coordination on all proposed operations is in everyone's best interest. We also strongly support the staff's proposed changes in Draft Rule 1202C, wherein the required buffer distance in which no ground disturbance would be permitted would be increased from 300 feet to 500 feet for protection of aquatic high priority habitat areas like cutthroat trout habitat and sport fish management areas. In addition, we request the Commission adopt 1/4 mile buffers for the estimated 59 miles of gold medal trout streams and 562 miles of native cutthroat streams within producing oil and gas basins, as well as for habitats important to state Tier 1 species of greatest conservation concern. Thank you. I look forward to any questions you may have, and I will now pass the baton to Ashley Rust.
Good afternoon, Commissioners. Thank you, Dennis. My name is Ashley Rust, and I am testifying on behalf of Colorado Trout Unlimited. I am a research scientist on the faculty at Colorado School of Mines, and my specialty is in hydrology with a focus in water quality. So I'm here to talk about the benefits that riparian areas have for streams in protecting their water quality, and to encourage you to maintain riparian buffer zones as wide as possible. So here's some pictures of some healthy riparian areas. And I'm just going to build on what Dennis just spoke to you about. Healthy riparian areas provide a free environmental service, protecting streams from water pollution from disturbed landscapes. They protect aquatic ecosystems and water resources. Sarah, if you can switch to the next one. Next slide, please, Sarah. Thank you. Here's some photos of some impaired riparian areas or absent riparian areas and what happens to the streams. Streams with impaired riparian areas lose these benefits, and the streams are vulnerable to physical pollution, such as warmer temperatures and sediment delivered to the stream, as well as chemical pollutants transported from nearby human development and non-point sources. Next slide, please, Sarah. Thank you. And so here's just a diagram, a simplistic diagram of riparian areas to show you how they are connected to the stream. They're this transition zone from terrestrial to aquatic, and they are connected to the groundwater. The water flowing in rivers comes from runoff from precipitation, such as rain and melted snow, and rivers are also fed by groundwater in low precipitation times. Rivers and groundwater supply water for all of our municipal, agricultural, and industrial uses. Rivers are inherently vulnerable to landscape disturbance. Healthy riparian areas not only protect water quality, but they also provide shade to cool the river and maintain stable temperatures for cold aquatic life. And the riparian areas are a source of food for aquatic ecosystems, delivering leaves and terrestrial insects to the fish and aquatic life in the streams. Next slide, please, Sarah. There's a longitudinal connectivity that riparian areas have too. It's not just that slice we just saw. Degradation of streams and riparian areas has an impact downstream as well. Pollutants from upstream can have impacts on all water users downstream, including neighboring states, as we are a headwater state responsible for the water we deliver to our neighbors. Next slide, please, Sarah, and this is my last one. Riparian zones act as physical and chemical filters for stream water. Plant roots take up pollutants and trap sediment. Healthy soil with organic material absorbs pollutants through charged attractions, and bacteria in the soil digest and detoxify pollutants, as well as nutrients and other inorganic chemicals. Riparian areas reduce sediment, nitrogen, phosphorus, and chemical pollutants from entering water and polluting the water. These conditions are nearly impossible to replicate and replace once degraded. It is much better for aquatic life and water quality if riparian areas remain intact and are as large as possible. Thank you. And now I will turn it over to Corey Fisher so you can hear from him, also from Trout Unlimited.
All right, thank you, Ashley. Good afternoon, commissioners, and thank you for the opportunity to testify today. Again, my name is Corey Fisher, and I'm the Senior Policy Director for Trout Unlimited. I want to talk to you a little bit about the importance of these buffers as they relate to Colorado's fisheries. And Colorado is famous for its gold medal fishing waters, as well as native cutthroat trout streams. And native trout occupy a fraction of the waters where they were historically present, and numerous partners, including state and federal agencies, have made a commitment, work cooperatively to prevent further declines of these species. The nature of oil and gas development, the footprint on the landscape, and spills that occur necessitate a cautious approach. Trout require cold, clean water, so they are the canary in the coal mine for watershed health and water quality. Impacts from energy development can include erosion, dewatering, sediment loading, contamination from spills, the impacts of which can range from catastrophic to negligible and can be both short-term and long-term in effect. One effective way to avoid or minimize these impacts is through the use of buffers. The idea that the closer a well or infrastructure is to a stream, the greater the likelihood that a spill or sediment will impact aquatic life. Now, there's no magic distance to guarantee that there will not be impacts, but there is a distance at which the degree of risk is acceptable given the value of the resource that's in need of protection. And simply put, 500 feet from the most valuable fisheries in Colorado is not sufficient. Across the West, federal land managers have grappled with this question and more have come to the conclusion that a quarter to a half mile no development buffer strikes the right balance. In fact, recently the Trump administration came out with a new management plan in Montana in which the BLM adopted a half mile no surface occupancy buffer for high value fisheries. And in Colorado, the preferred alternative for the Eastern Colorado Resource Management Plan proposes a suite of NSO buffers for the South Park region, including a quarter-mile buffer for gold medal waters and a 400-meter buffer for water bodies containing native cutthroat trout. I urge the Commission to adopt a quarter-mile buffer or setback for stream segments identified as high priority habitat, which are gold medal waters or cutthroat trout streams. We feel that a buffer of 500 feet is appropriate for other aquatic high priority habitat. Now, should the Commission elect to not include a quarter-mile buffer for these aquatic resources and instead adopt a smaller, less protective setback, it's imperative that spill mitigation BMPs be required for lands outside of the adopted buffer and up to 1,500 feet. The reason being that 500 feet may be effective to reduce impacts from erosion and sediment, but not to guard against the effects of spills. Thank you for the consideration of my suggestions, and I'm happy to take any questions.
Great. Thank you to our witnesses. Their verbal testimony today is supported by their written testimony that's been submitted, by the publications that they cite therein, by the statement of basis and purpose, and by the literature cited in that statement. So now this slide, so if you could bring it up, contains proposed rule language to implement the changes referenced in our testimony and supported by our pleadings and by the literature. First, language would be added to Rule 1202A, requiring that operational practices to protect water quality be implemented at new locations within 1,500 feet of all aquatic high priority habitats. These are the same measures that would be required when drilling in the intermediate zone set out in Rule 411 in proximity to public drinking water systems. Examples of such measures include keeping spill response equipment on site, using tanks instead of pits, lining berms, and the like. Second, the language in Rule 1202C would be modified to provide for a quarter-mile buffer for designated cutthroat trout crucial habitat and gold medal streams, as Corey Fisher testified. As Dennis Beekler mentioned earlier, this would amount to 59 miles and 562 miles, respectively, within Colorado's oil and gas producing basins. These changes are necessary to meet the standard in Senate Bill 181 to protect wildlife resources, in particular those that rely on healthy aquatic systems. Now we'll move on to a discussion of big game protections, starting with Dr. Kevin Alexander. Kevin?
Yeah, can everybody hear me okay? We out here in Gunnison, we haven't had internet all day. So I just now got connection and things like that. Our one trunk line got cut next to Montrose, and John Mesner will kind of back me up on that one, I think. So
well, I'm glad we're able to hear you, so good.
Good. Well, I'm Kevin Alexander. I'm a field biologist with over 30 years of professional experience. Today, I'm testifying on behalf of backcountry hunters and anglers in relation to big game and terrestrial wildlife. I appreciate your service, and thank you for hearing our testimony on the 1200 series proposed rule. First, I'd like to start that this law and rules are much better for big game and terrestrial wildlife than what previously existed. So this is a very positive step. So thank you for working on these rules and making them the best that they can be by considering our recommendations, those of other biologists, and are summarized by the edits presented by Bob. Maintaining healthy landscapes with functional big game and terrestrial wildlife populations is a conscious choice that we make as a society. Keeping those necessary habitats protected through the alternative location process is an excellent tool to maintain these healthy and productive landscapes. Scientific research clearly shows that increased human presence on the landscape reduces the health of our most vulnerable wildlife populations. There are levels of landscape alteration that varies by species to where a tipping point would be reached and those wildlife populations crash to unsustainable levels. Secondly, habitat use varies throughout the season and probabilities of wildlife being at a particular location also varies throughout the season. For example, migration corridors are critical as wildlife surf the green wave of select greening vegetation throughout the year. Scientific studies have shown large ungulates follow the greening of vegetation during their migration seasons. These migrating ungulates have more fat stores, thus are healthier and can have greater survivorship and better offspring production than non-migratory populations. These migratory routes are also ancient routes that have most likely been occurring for nearly 10,000 years. There are paths worn into the landscape from countless hooves, moving across the same paths year after year. This is a spectacular biological phenomenon that cannot be replicated through mitigation elsewhere. To really manage big game and terrestrial wildlife populations well, we have to protect these phenomena. The more probabilistic models of landscape use shown on this slide, where aspects of a landscape are plotted on the probability of wildlife occupying that habitat at different times, gives a much more accurate depiction of habitat use by wildlife species on the landscape. It also informs the process by helping determine areas where impacts need to be reduced or avoided and where mitigation may be most appropriate. Lastly, one assumption when conducting science is that science is universal both in space and time. Science works well for wildlife and fisheries. There are nuances based on landscapes and habitat types, but generally what we learn in one area can be applied to others. I encourage you in your decision making to use totality of data and the science directly from the biologist when making final decisions. Thank you for your time, and I'll turn this over to Janet George for her remarks.
Good afternoon, Commissioners. I'm Janet George, and I'm representing the Colorado Wildlife Federation. The purpose of my testimony is to advocate for rules that allow oil and gas development in a manner that protects high priority habitats for bighorn sheep and for mule deer, elk, and pronghorn. Colorado Wildlife Federation is in support of Kevin Alexander and Ed Arnett's testimony for deer, elk, and pronghorn, so I will focus on an overview of the Federation's evaluation of proposed Rule 1202 as it addresses bighorn sheep. The Colorado Wildlife Federation largely supports proposed rule changes for the 1200 series. We appreciate that bighorn sheep production areas are now listed in 1202C with no surface occupancy because disturbance can result in lamb mortality, both direct or indirect. However, including other bighorn sheep high priority habitats in Rule 1202D does not provide sufficient protection. Colorado Wildlife Federation proposes rule changes to improve 1202 by placing bighorn sheep winter concentration areas, severe winter range, and migration corridors, especially the pinch points, in a category that does not allow surface disturbance to exceed 3% of a section. Bighorn sheep, especially ewes and lambs, exhibit high fidelity to their range. In other words, bighorn sheep do not pioneer new ranges well. Bighorn sheep behavior patterns are extremely rigid and ritualized and play an important role in population persistence. Migration allows bighorn sheep, like other big game species, to maximize energy and nutrient consumption by synchronizing movements with emergence of high quality forage across the landscapes. Movement patterns also allow animals to avoid the harshest winter conditions. Indeed, research has found that migratory bighorn populations have greater population sizes than sedentary populations. Bighorn sheep range and movement patterns are learned behaviors passed along through generations. Bighorn sheep are also especially susceptible to respiratory disease, which predisposes them to periodic large-scale mortality events. Environmental stressors have been associated with some of these large mortality events and are likely due to reduced immune system function. Dust from construction and maintenance activities also predispose bighorn sheep to respiratory disease. Bighorn sheep are iconic of our Mountain West and Colorado state mammal. They are highly valued by wildlife viewers, photographers, and hunters, and add to the quality of life for all Coloradoans. Thank you for your time and consideration, and I'll pass it off to Liz.
Thank you. Good afternoon, Commissioners. Thanks for reading and listening to my testimony and that of the other wildlife hunting and angling group representatives. I'm an outdoors woman who chooses Colorado for home, and I'm testifying on behalf of the Colorado chapter of Backcountry Hunters and Anglers, for which I'm a member and chapter leader. I'm also part of a growing number of women in Colorado who have found hunting and angling to be incredibly empowering and valuable. My perspective on management of natural resources stems from my work in the oil and gas industry from 2012 to 2018, from learning to hunt in Texas and Colorado, and from studying environmental policy in a Colorado master's program. In the last decade, developments in technology and improvements in operations for drilling and completing wells has advanced tremendously. At the same time, we've learned a lot about human impacts to wildlife, particularly in the West. So as presented by my colleagues before me, the research shows that in high priority habitats, we need to be very cautious if we wish to maintain healthy big game populations. For this reason, we ask that the COGCC require operators to avoid development above that 3% density threshold where possible. And we ask that the COGCC also adds rules to ensure that the biologically significant areas within migration corridors are protected by no ground disturbance where CPW deems it necessary. We know that in some environments and for some big game species, the biologically significant areas within migration corridors, which includes stopover areas and bottlenecks, are crucial to ungulate's success and population health. So it's appropriate to include considerations for these particularly important components of migration routes because we know they exist and we know they can be key to individual and herd survival and stability. So while not all stopover areas or bottlenecks have been mapped yet, they will be mapped by CPW in the future, and those maps will be open to public review before they're utilized. I worry that Colorado's wildlife, particularly big game animals, face such a wide range of threats already, from energy and infrastructure development to wildfires and drought. Deer, elk, pronghorn, bighorn sheep, and the wildlife that shares their habitats are so iconic in Colorado and support the way of life that so many of us choose. So I believe we have to protect the big game habitat, the high priority habitat and migration corridors as best we can in any sort of planning and development if we wish to maintain healthy populations into the future. We are wise to have these discussions as the COGCC updates its rules. So thank you so much for the opportunity to voice my concerns, and thank you for your time and attention. Next, Bob Randall will wrap up our group's presentation, and I look forward to questions following.
Thank you, Liz, and thank you to our other witnesses. Now we'll bring up a slide that contains some proposed rule language to implement the changes that were referenced in our testimony just now. This language would apply to each of the 4 big game species: elk, mule deer, pronghorn, and bighorn sheep, and the habitats that CPW has identified as the highest priority for each, including migration corridors, production areas, severe winter range, and the like. The language references the 3% density trigger that we discussed, where ground disturbance would be prohibited when a new location would result in surface disturbance exceeding 3% of the section. CPW this morning talked about a desire to keep the entire landscape permeable and functional. Our testimony in the scientific literature points to restricting further development once a 3% density trigger has been met as the best mechanism to do that. Finally, our proposed language would prohibit ground disturbance in biologically significant areas of these species migration corridors. As Liz just referenced, this is a reference to bottlenecks, pinch points, or stopover areas that are of particular importance to these species during their migration between seasonal ranges. Again, CPW's presentation this morning acknowledged that best available science supports protecting these areas by avoiding placement of facilities in them. Just as offsite mitigation is an effective strategy to offset impacts to migration corridors, is an ineffective strategy to offset impacts to migration corridors due to animals' fidelity to particular routes, there's no evidence to indicate that a broken migration corridor due to disruption of these biologically significant areas can be mitigated or repaired. Protection of wildlife, as called for in Senate Bill 181, requires protection of these irreplaceable habitat areas. As we said in our pre-hearing statement, we recognize that the effort to identify and map these areas is ongoing. We've therefore acknowledged that this provision would not go into effect until CPW completes its research and the COGCC maps are updated. Should the Commission adopt our proposal, we would support insertion of language into the Statement of Basis of Purpose, recognizing this fact. So that concludes our presentation this afternoon. Thank you to you all, to Director Murphy and her team at COGCC, and to Mr. Ackerman and Mr. Holst, and the entire CPW team for their engagement on this important subject. We look forward to taking any questions that you all have. Thanks.
Great. Thank you, Mr. Randall, for coordinating your panel of witnesses for us this afternoon. Commissioners, do we have questions? Commissioner Messner.
Thank you, Mr. Chair. And thank you all for that testimony. I found that very informative, and I appreciate that. So my first question is, and this is going to be for Mr. Fisher. Did you have an opportunity to hear the testimony of the industry group and Mr. Coleman, I believe, prior to lunch?
No, I did not.
Okay. So he had provided some information about 14 different BLM resource management plans, and also some examples of some decisions around setbacks from the BLM that seem to indicate that the typical setback was well within the 500-foot buffer that's being proposed here as kind of a general rule of practice within the BLM decision-making around wildlife. You've brought up a few examples here, and I wonder if you could just bring them up for me one more time. I understand they're in your written testimony, but I think that these are good. The testimony that you provided around and I think they were all BLM decisions as far as setbacks for, a half mile, a quarter mile, and there was one other one. These are recent decisions that were made, or maybe just color that a little bit for me, would you?
Yeah, absolutely. So, just looking at Colorado, there's the Little Snake Resource Management Plan, which it's starting to get a little bit dated now. I think it's about 8 to 10 years old. That was a quarter mile for really all streams. And then going down Tres Rios to San Juan National Forest, they did a joint resource management plan. I think that's 4 or 5 years old. And that one was they had that quarter mile, as it talks about in my testimony. Again, just the past summer, it was the BLM in Montana that did a half-mile buffer, and that follows, there's been a series of resource management plans in Montana in which they've done those half-mile buffers, starting from this past summer through plans within the last decade. So those are all, recent examples. And of course, there's examples where there's less than that, like down in the Uncompahgre plan that just came out that was pretty roundly criticized for the lack of protections down there.
Okay, thank you for that. One other question that I had, and this is just a general question, and it's actually a legal question a little bit, so maybe Mr. Davenport or Mr. Minor, I think, is on AAG Davenport, AAG Minor, but what's the legalities around utilizing prospective language within a set of rules that would not go into effect until some future data set was created as being proposed here?
AAG Davenport.
Thank you, Mr. Chair. The commission can create a rule that goes into effect in a specific future date. That the APA provides that ability, and the commission has done that in the past to set rules that go into effect at a date different than maybe what would have been the earliest possible effective date under the standard procedure under the APA.
What about utilizing not a date certain, but when available data is available, which is kind of what's being proposed here a little bit?
Well, I think you'd want to be very clear about when that is, because otherwise, if the rule itself is not clear, you've got a difficulty in when the rule becomes effective. I'd have some difficulty in determining exactly what that date would be. I would want there to be some very clear guidelines on when that data may become available or effective. It creates some uncertainty, and that's what makes me uncomfortable in regard to having a rule that you can effectively enforce.
Thank you. I appreciate that. I mean, I do I do appreciate and understand, and I think we even heard from CPW staff clearly that, migration corridors are important. These pinch points, these stopovers or biologically significant areas are important. It does seem like there's some challenges around some of the mapping or data on that right now. So I'm certainly open to future conversations and discussions and testimony about it as we're doing this rulemaking, but that does seem to be a challenge right now.
Mr. Randall, would you like to respond?
Thank you, Mr. Chair and Commissioner Messner. I do think this is an important discussion to have. Our sense was that Senate Bill 181 directs the Commission to adopt regulations that will protect wildlife, and that the Commission is, so long as there's an adequate record and it's factually supported, the Commission could elect to adopt a rule that says that these areas are to be avoided. We also recognize that that wouldn't go into effect until the maps interpreting that rule, sort of consistent with our earlier argument about the maps under the APA, that they wouldn't go into effect until those maps are promulgated in whatever form you all decide ultimately to do so. But a finding that protection of these areas through no ground disturbance is necessary to protect wildlife, our sense was that that was within your power. I take AAG Davenport's point to heart that there might be some enforcement challenges, but in as much as this just comes forward as a permit application, it seems to me that those maps would be sort of the trigger both for the operator and for the Commission as to whether or not the rule would apply, and until those maps include these areas, they wouldn't. So there wouldn't be necessarily an enforcement action underway. But anyway, I just wanted to sort of share our approach on that. We recognize that it's a challenge, but that was how we thought through it.
Other questions from commissioners? Commissioner Nanjapa?
Thank you, Mr. Chair, and thank you all for your testimony today. That was very helpful. I had a couple of different questions. One in particular was, you all noted some of the other threats that big game are experiencing, just habitat fragmentation and development and other things. I was just curious if you could speak a little bit to the adaptive potential of these species to be able to find other corridors in the face of these other types of development. I just want to better understand kind of what we know about that.
Mr. Alexander?
Yeah, as far as migration routes, there's very little to no data supporting that animals tend to shift to different migration routes. It's not been studied tremendously, right? But most of that data comes out of Wyoming, Montana. But there's no credible evidence that they really are successful in changing major migratory pathways. There is really strong evidence that they quit migrating when that gets blocked. And when that migration gets blocked, they do not perform as well. Their chances of surviving winter are substantially reduced, and then their fecundity also declines.
Mr. Buechler, I'm sorry, I probably don't have your last name pronounced correctly, but please.
Buechler, like the beak on a bird. I just want to remark that we used to laugh in the Wildlife Commission that these animals don't read maps very well. So if you were to draw a different corridor line, they might have a little trouble following that. So it's just a side comment.
Commissioner Nanjapa.
Thank you, Dr. Alexander and Mr. Buechler. I think I got, is that correct? Buechler, okay. I did actually have a question for you, Mr. Buechler, about when you were talking about the wetlands and the riparian areas and sort of emphasizing the avoidance of impacts. I think you mentioned that the mitigation fee or the banking type activities were not sufficient. I was curious what your thoughts were, though, in the realm of sort of if in certain areas, you know, with certain conditions of approval and with adequate buffers met, if there could potentially be some forms of mitigation that would maybe reclaim other existing oil field areas or well pad areas that maybe were, you know, historically done, but perhaps not as well as our current rules, you know, would require, or if there were other sort of habitat improvement projects that could ultimately result in a net gain. Just curious if you could comment on that.
Oh, absolutely. It's always a preference to try to replace lost habitat values as close as possible to where the impact occurred. But the main thing is to be within what the mitigation banks call a service area, within a relatively decent area. And the focus should be on in-kind. In other words, if you're losing wetland with a variety of species in it and so forth, anybody can go out someplace and create a cattail marsh, but it's not the same thing. And but definitely there's opportunities out there. In fact, that's when we worked with developers under the Section 404 program, Clean Water Act. That was one of the first areas of emphasis, was to look around for spots that had been impacted in the past, but could be reasonably restored, because in wetlands, the seed bank is usually there. And often it's a matter of restoring hydrology to these wetland species and restoring their hydrologic regime, which I may be stepping into. Other people have more expertise in this, but it's done all the time, actually. But the key, though, is that when you claim credit for restoring a habitat, you can't do it necessarily on an acre per acre basis. You have to, for example, if you destroy 10 acres of pristine habitat and you want to replace it, it's going to take more than 10 acres because there's still some values already there. You're just enhancing the values that are there. Does that make sense? So that's why the consultation with Colorado Parks and Wildlife is so important, because they know which wetland types are more rare than others, and how susceptible they are, and how well they respond to mitigation efforts, because we are in a very arid climate here. And so the problem with mitigation a lot of times is that people don't commit or don't have the money, and oil and gas industry doesn't really have a great reputation with regard to this, but they have to be maintained through time. Otherwise you lose those habitat values over a time cycle. So you can't just go in there and move some dirt, you know, and check the seed banks and then move on. I mean, you have to make sure the hydrology is there to maintain that habitat for a long time. I'm sorry, did I answer your question? Too much, probably.
No, thank you very much, Mr. Biegler. That was the information I was looking for. Thank you.
Other questions from commissioners? All right, I'm not seeing further questions. Thank you all for your presentation, for your written testimony, for your oral testimony today. We do appreciate it, and we thank you for staying with us this afternoon. I believe we have one more panel this afternoon, which is Crestone Peak Resources. So Ms. Larson, if we could bring Crestone into the house.
Yes, we will get them in. And just to note, Citizens for a Healthy Community have requested to go tomorrow, so we will have them come in tomorrow.
And we'll try to find Mr. Doe tomorrow as well, give him a shot.
Yes.
And then the Moffett, Rio Blanco, and Mesa counties that was on the agenda, they have ceded time with Western and rural local governments, I believe.
That is correct.
Good afternoon. I want to make sure, is David Stewart on? I'm here. Can you hear me?
Yes, we can hear you, Dave.
Okay, great. All right, I'll get going then. Thank you. Good afternoon, commissioners. Thank you for hearing my testimony today. Crestone Peak Resources is a responsible operator. It is leading efforts on operational practices to protect wildlife resources. And we appreciate the opportunity to comment today. Next slide. Generally, Crestone supports the rule changes and appreciates staff efforts to include consultation and flexibility in working with CPW on wildlife resource issues. There are three primary suggestions that I would like to address today. We ask that the Commission refer to the CPW guidance for raptors, include a waiver process in the proposed Rule 1202.c, and modify Rule 1202A5 to increase the number of days trenches can be left open before requiring wildlife escape ramps. In addition, Crestone supports the positions set forth by API Colorado in their testimony presented to you today. Next slide. We asked that the proposed Rule 1202C include a waiver process to align with current CPW guidance. CPW considers site-specific aspects to determine distances of non-activity rather than an absolute buffer zone. Some of these aspects are listed on the slide and covered in the Raptor guidance document. One of the main concerns with no waiver process is that the raptors may move within the buffer zone after initial consultation in the permitting process. We believe the consultation process with CPW is effective at managing wildlife resources and ask that the proposed Rule 1202C include a waiver process. This change would allow CPW to continue evaluating sites using shrewd judgment on potential for risk and development of reasonable mitigation measures. Next slide. With consultation, mitigation, and monitoring, Crestone has been able to work successfully near and even within CPW recommended buffer zones with no adverse impacts on raptor species. An example is our Dreamweaver pad, located about a half mile from a riparian area that is used by bald eagles as a winter roost site. There's also a bald eagle nest, other raptor nests, and perch sites nearby. Initial consultation occurred prior to permit issuance, and then it continued multiple times throughout a 3-year permit to development process. In that time, raptor nests, perch sites, and bald eagle winter roosts have moved numerous times. CPW needs to remain flexible in its determination of variances and mitigation requirements to account for the dynamic behavior of wildlife resources. Next slide. Rule 1202A5 requires wildlife escape trench installation. We believe this requirement is unnecessary when personnel are inspecting trenches at least daily and creates additional risk due to the potential for stormwater intrusion into the open trench. We request that the 5 consecutive days be changed to 14 days with the caveat that daily wildlife inspections would be required. Next slide. In conclusion, we urge the Commission to refer to CPW guidance in considering the 1200 series rules, request that the Commission include a CPW waiver process in Rule 1202C, and modify Rule 1202A5. Crestone appreciates the opportunity to comment, looks forward to continued collaboration with the Commission and COGC staff on developing the 1200 series rules and requirements. This concludes my presentation. I'd like to reserve our remaining time for our response. I'm happy to take any questions you have.
Thank you for your presentation. Commissioners, are there questions for the panel? Commissioner Messner?
Thank you, Mr. Chair. And thank you for the testimony. Help me just to understand a little bit here, though, on the 1202A5 trench thing. I mean, is the concern that it's too expensive, it's problematic, it's, I mean, I guess I don't see what the big deal is, I guess, about putting in ramps. So maybe I just need to know more about it.
Sure, I don't think the concern is really related around cost or difficulty putting in ramps necessarily. My concern is mainly that during a storm event, those same ramps would also lead to excessive storm water, could collect down into the open trench, leading to issues with the trench walls degrading, and problems with just filling that trench with water prior to putting in your pipeline creates all kinds of construction related issues that we're trying to avoid all the time. Also, in my experience, we've never had wildlife in a trench that was open during excavation period. So not against the ramps necessarily, just want to point out that this creates an additional stormwater risk.
Okay, that's helpful. Thank you.
Other questions from commissioners? All right, seeing none, thank you for your presentation and for your written testimony and the work you did today. We appreciate it. And we will, I think, conclude today's portion of the 1200 series hearing. Again, the Citizens for Healthy Community will go tomorrow. The Moffett, Rio Blanco, and Mesa counties are with the Western and rural local governments. And we will give Mr. Doe a chance tomorrow to also testify with Be the Change, since we were not able to hear from him today. We have the rest of our stakeholders ready for presentation tomorrow. Tomorrow is Friday, November 13th, and we are going to begin at 9 a.m. So unless there is further discussion amongst commissioners, I believe we're looking for a motion to adjourn until Friday, November 13th at 9 a.m.
So moved.
Second.
All right, we have a motion and a second. All those in favor signify by saying aye.
Aye.
Any opposed? Great, we are adjourned. Thank you to the 108 participants that joined us today, and we'll look forward to seeing everybody tomorrow morning. Bye.